early on when I got angry at a press conference, and then I saw it that night, and nobody would have listened to any. I might have been substantively right, and I still think I was, about what I was angry about, but nobody's going to listen to me, and nobody's going to like it. So in front of the jury, you've got to be the person they go back there and say, one or two or three things. You want them to say, I really admire the way they fought for their client. Then you got to figure out how to define fight. Is fight angry and aggressive and so on in your face, or is it just insistent and consistent and repeated in every way? And I would suggest the second way is the way you want them to think about it. Do you concede in front of the jury things that you think that are worth conceding? Yes. Do you argue with the judge? I've become very good friends recently with a woman named Letitia Quinones. And Letitia is more aggressive probably with a judge than somebody might think. But it works for her. And it works for her because she's still courteous while being that way. And I labor under the problem that every time I now, because of my age, which I'm not a big fan of admitting or conceding, judges think I'm going to try to take over the courtroom. And so they come out at me now almost uniformly, pretty aggressively, to make sure I understand who's in charge. Okay? So I spend a lot of time kissing ass in trial, basically, to try to make sure the judge doesn't unload on me in front of the jury unless it's unavoidable. Because we all know whether that judge deserves it or not, in the real perception of the public at large, the jury thinks they're right and we're wrong, no matter what position they're taking. So you don't want to get into a fight with the judge if you don't have to. But now you're in jury selection and you tell them who you are. You let them know nicely. Try to not do it in a preaching way. I watched the CEO of the coffee company last night, Schultz, Starbucks, and he had a repeated speech pattern. Did anybody see it on CNN? All right, so they had a town hall with him last night, but what he always did every time and the whole thing is questions from the audience. Every time he said, thank you for your question. Well, that's fine the first time or two. But after a while, it sounds rehearsed because he said it every damn time. Okay? And you don't want to do that. But you want them to feel like you care about them. I've always looked at a jury as a chance to meet felonies, misdemeanor, a lot less, a chance to meet 40 people I've never met. I want to know about them. I want to know what they think, what they feel like. When I started out picking juries, the first 6 months, of course, as I was a prosecutor in misdemeanor, I picked juries the way I thought a real lawyer did, This type of group is bad for this kind of case, whatever it was. And after about 6 months, I thought, I'm not comfortable with this. I don't like this. So I decided, and this is why I'm such a big fan of misdemeanor court. I mean, if I lose the case as a prosecutor in misdemeanor court, I'm not letting Jack the Ripper go, right? And so it's a wonderful place to experiment with the way you do things in your own mind, decide what works, what doesn't. And this is going to be particularly true for you as you feel your way because of the lack of experience before. So what I started doing is look, I think I'll start leaving on juries people I like. Or at least trying to make that's who it is. And I'll cut people that come from a group I don't like. So, though I grew up in the South during the ages of segregation, I don't like rednecks. I'm not comfortable with them. I grew up around them. I can talk to them. But I don't want to try to persuade them of anything. So as a prosecutor, a redneck was supposed to be good, right? They're going to be strong law enforcement, anti-defendant, etc. I still always struck them. Because I didn't want to spend any time trying to persuade somebody that I wasn't comfortable with as a human being to my point of view. My view was, I want to leave on the jury people that I'm comfortable with as a human being, as much as possible. Strikes, obviously you don't have enough strikes to get all that, particularly if you're on the defense side, but I would start leaving on the jury people that didn't make any sense. So back as a prosecutor, in 1977, I had a jury with 6 blacks, 3 Hispanics, 1 Indian, and 1 Indian, and 2 whites. They were great. But it was not because there were 6 blacks or not because they were Hispanics, but I had had an opportunity to say a few words to each one of them and listen to them to form an impression of what I thought about them as human beings. I determined early on I wasn't going to pick or exclude juries based on what group they came to. Wasn't age, wasn't sex, wasn't, if you can figure out what someone's sexual preference is during jury selection. There's some that are obvious, but a lot that aren't. But I wasn't comfortable with that. I didn't live my life with that way, so why would I do a trial, try to persuade people where I didn't live my life trying to appeal to that group as a group one way or the other, but individual. So what I decided to do is that I would try to always be sure that I spoke to each juror, if at all possible, for a minute or two. When you're trying misdemeanors, you don't have time. It's really hard to do that. I understand it because they don't give you much time at all. But in felonies, I wanted to at least listen to that person talk. And it was reinforced one time when I had a trial, again as a prosecutor, and I left this guy from Mobile, Alabama on the jury on the biggest whale I had ever tried as a prosecutor. And what happened was I was the chief, my 3 was sick, and it was an auto theft case. And he was caught driving a stolen car and he ran from the cops. I mean, how hard is that, all right? And so it should have been a laydown. And so I was going through jury selection and I was running out of time, and there was this white guy from Mobile, Alabama that looked like a real state's easy going to be jury. Defendant is black. He looked like he was a racist. He dressed, if we make those kind of deals, just made me think that. I grew up in North Carolina. My wife's from Alabama. I know Mobile, Alabama. So I left him on the jury without ever talking to him. It was such a lay-down whale, I waived argument. It was just so obvious. The jury goes out, and they're out, and they're out, and they're out. And then they go to lunch. We argued at 9. It's like 12:30. One judge expected a quick verdict. They're out. They go walk around courtroom, and as they're leaving, we notice they're missing one. And the bailiff realizes it. So he goes back into the jury room. It was my guy from Mobile. The jury was so mad at him, they'd locked him in the bathroom to keep the foreman from throwing him out the window. And he said, I'm never going to convict, because the rest of them thought it was as obvious as I did. And the reason was he had seen this guy, the defendant, in another life, and that meant God was telling him not to convict. Well, those kind of views I might have sensed if I had talked to him. But I've made a fatal mistake of assuming because he came from a certain demographic group, he was going to react in my favor. And I've never, ever, that was 35, 40 years ago. I've never forgotten it. And so that's why I say I want to talk to them. I want to see how they react. That's why I don't like to try cases in federal court any more than I have to, because we don't have any real input in the jury selection as a whole. The judge is basically doing it. And I can't explore their attitudes, and I can't talk and see how they feel. And I'm a big believer in feel questions. How do you feel about this? What do you think about that? So in jury selection, I will want the jury to try to get comfortable with the person. And you look at jury selection as sort of like a two-pronged deal, in my view. Everything I'm telling you is just simply my view. I'm not saying it's right or wrong. I'm just saying it's the way I do it. And I want to spend half my time on what I call indoctrination, and I want to spend half my time on eliciting information. So it really should be the other way around. So I'll start out with open-ended questions with a juror trying to figure out. And you, in turn, on the defense side, are going to want to be getting them, how do they feel about certain things? Let me ask y'all something. How many of you think that if a defendant doesn't testify, actually before we even get there, how many of y'all think because he's here, he must have done something. How many of you? You get no answer. If you ever hear a lawyer say, I take it by your silence you do not, that lawyer does not have any freaking personality. Because all not saying something means is you haven't connected with them. Silence is not acquiescence. Silence is mean they're not with you. They're not listening to you. They're not going to help you. So what I would do is come on. Let me try again. How many of you think that because he's sitting there, he must have done something wrong? Miss Jones, how about you? And so then I don't have it. Still, then what I say? And then I will explain. Look, let me explain something to y'all. If you really don't want to be here on this jury, then you need to tell me what you think. Because if you don't say a word, your chances just shot through the roof of being on this jury. So I need to know what you think. And you understand, you've taken 2 oaths. And I said this, started doing it as a prosecutor, and I still do it as a defense attorney because I think it plays to both sides. When y'all were over in the jury room, you were asked to take up and swear, and you were asked to truthfully ask whatever questions are propounded to you by the judge or the lawyers. And you swore you'd do that. You have not sworn to not be angry. You have not sworn to not be biased. You have not sworn not to be pressured. You can hate lawyers, and you are totally within your right now. You can not want to be here, and you're totally within your right. But once you take the jury box, then you take a second oath. That oath is to render a true verdict based on the law and the evidence. And then it'd be a violation of your oath to act on a bad experience you've had, a bias or prejudice you might have about one thought or the other. So what I really want to talk to you about for the time I've got going, and by the way, ask your judges not to tell the jury how long you're going to be up there. Every trial I want to ask the judge, do me a favor, whatever time limit you're going to put on us, don't tell the jury that. They'll stop listening. They'll keep looking at the clock and everything. So I never want the jury to know how long I'm going to be there. And I'll never tell the jury how long I'm going to talk to them. And say, look, I want to try to make sure you don't get caught in that being asked to violate your oath. Because if you get back there and all of a sudden decide, I just don't like a certain type of person, or I was the victim of a crime one time before, and of so-and-so, and I swore I'd never somebody, if I ever had a shot, I'd take care of that. That'd be a violation of your oath if you're a juror. It is not a violation for your oath to feel that way. The only oath you've taken so far is to tell us what you think, and truthfully. So, on the first row, will everyone agree that you will tell me any and everything truthfully that I ask you, or that you even think I should know, knowing as you sit there, I represent someone who's faced with a felony charge and has their whole life in front of them on the table. So, if you're a juror in this case, I want to ask each of you, and I'm going to go by row, as to whether you can assume right now. Well, I don't assume. I would get to that later. But you could say, as you sit there right now, you're going to tell me everything, particularly any feelings you have that you feel like are responsive to what I'm asking you. How about the first row? Can everybody tell me that? I don't see any heads. I don't hear any amens. I don't hear anything. Let me try again. On the first row, can all of you do that? You never, ever let them get by with not responding. But you need to be doing it nicely. You need to be doing it in a way they're comfortable at. And don't ever listen to this thing about you can't show humor. I never forget, there was a juror who looked like he had really long hair. He looked like he had been dropped in from Haight-Ashbury. He'd been frozen in the 1960s in Haight-Ashbury in San Francisco and dropped in this courtroom for this trial. All right? And I was asking, could you consider, I was trying to qualify people to be on the jury that were strong-minded as a prosecutor. And I said, can you consider as little as life in prison for somebody charged with something, as well as, no, I think I was trying to qualify him on the bottom. That's right. So could you consider as little as 5 years probation for the crime of murder? And he looks at me and he goes, I can consider anything. The jury dies laughing because they looked at him and the way he was dressed and the way they thought that was a very truthful statement. And so I started laughing, and then every time I turned around, and then every time I got ready to ask another question, I'd look out there and see that guy, and I'd start laughing all over again, and the jury would know. But I was laughing because it was funny. If you look at a guy, and you got to let the moment, you got to be comfortable with the moment, is the point I'm making. And so if I'm talking to them, then the first thing I want to do is to get them committed to talking to me and answering my questions. I want to make them feel like it's a violation of the oath they've taken so far not to. And then I want them to feel like it's a violation of their oath that's coming, if they're a juror, to act on something that's not about evidence and not about the law. So we go through that. And then there are the portions of the case that concern me. So obviously, defendant's not testifying. How many of you think that if a defendant doesn't testify, doesn't get on the stand, that probably means he's guilty? Actually, that's a very good way to put it. Let's do this. Let me ask you the question again, Mr. Juror, then. You're Mr. Wilson, by the way. Mr. Wilson for today, okay? Let me ask you, that's actually a good question, Mr. Wilson. Let me put the question another way. How many of you want to hear both sides? That's the way you grew up. I assume that's what you're talking about. Right. That's a natural thing. How many of you? If you don't get any show of hands, you stay after them. Everything you want to find out, you stay after them until they respond. And if you don't get any hands, and if it's still, at time of day or whatever, then you want to go back to them and say, all right, y'all going to make me call on you individually, or are you going to start raising your hands? And somebody will raise their hand and might say, how many of y'all remember the little kid? You always need an icebreaker, okay? Now, the two things I want from y'all. I don't want the kid who raises his hand all the time like he did when we were